0505, Candice Reis et al. Versus OOIDA Risk Retention Group, Inc. et al. Daniel Jason for appellant, Scott McMickle for appellee.
Gentlemen. Mr. Jason, when you're ready to proceed, we will be ready, sir.
Mr. Chief Justice and Justice, good afternoon. May it please the court, my name is Daniel Jason. I represent the appellants in the case. The sole issue today before the court, it's whether the Georgia's direct action statute regulates the operations of foreign risk retention group in violation of the Federal Liability Risk Retention Act, which is codified at 15 U.S.C. Section 3901 through 3906. The appellants contend that because the Georgia's direct action statute is a financial responsibility law, it is specifically exempt at 15 U.S.C. Section 3905 from the preemptive provisions of the Federal Liability Retention Act. Your Honors, as a background, the appellants were injured when their vehicle was struck by a commercial truck owned by Zion Train Express, Inc., which is a motor contract carrier and insured by the appellee, OOIDA Risk Retention Group, Inc., which is a risk retention group chartered in the state of Vermont. The accident happened in Georgia. On September 30th, 2015, appellants filed a lawsuit in the Superior Court of Newton County naming Zion Train Express and OOIDA Risk Retention Group as co-defendants in the lawsuit pursuant to the Georgia Direct Action Statute. During the deposition of the owner-operator of Zion Train Express, Mr. James Powell, who happens to also be a co-defendant in the case, it was determined through his testimony that as of September, the end of September, that the company had become insolvent, liquidated all the assets, and ceased to operate as a business. That's about 7 months after the accident and the same month that the lawsuit was filed. Additionally, we ascertained through the state of Ohio's corporate business records that the same motor contract carrier, Zion Train Express, corporate status was canceled in April of 2009, about 6 years before the subject accident. Without the direct action statute, the appellants would not have had any financially responsible entity to recover from. The lawsuit would have been subject to a dismissal for bringing an action against a non-entity because the corporate status was legally non-existent.
I think what you have here, Mr. Jason, as you're saying, you're arguing, I think the issue is going to be Georgia has a direct action statute, and the question is going to be preemption. Is that correct?
That is correct, Your Honor.
Yes.
Can I ask you, the fact that a company is insolvent at the time of the lawsuit, if it was an entity at the time of the injury, doesn't preclude you from suing them, right? You would have to sue them. They would either go into default or they would defend, and you would get a judgment, and then you could, without a direct action suit, you could go after their insurer, right?
Well, Your Honor, you can, but most of the risk retention groups, the motor contract carriers who are members of that association, or essentially sole member operators, the independent operators, would oftentimes want tractor trailer, which is their...
No, I get that it would be very difficult and complicated. That's why we have direct action statutes, but it doesn't make it impossible. It just makes it easier, right?
It makes it easier to have a financially responsible party to pursue for recovery purposes. But if a party has no legal status as an entity if their corporate charter has been dissolved by the state's corporate division and the company has ceased to operate, you couldn't sue them. I'm sure the appellee would have filed a motion to dismiss, which would have been granted by the Superior Court of Newton County in this particular instance. But because of the presence of the, I'm sorry, Your Honor.
I mean, I don't know that companies can declare themselves insolvent as a way of avoiding liability after the fact. Do you have authority for that?
Well, Your Honor, the simple fact is if you sue a party until he's served, you have no means of recovery. And Georgia's statutory provisions, you cannot recover money judgment until the person's served, and that requires personal service. In this one instance, you couldn't find him to serve him because it's liquidated, operates out of his bedroom. You wouldn't have a party to be served. Even if you serve and obtain a judgment, you wouldn't have any means of collecting it. So it would make the judgment essentially a paper judgment.
Yeah, but I think underlying the whole thing is the issue of preemption. I mean, that's how it kind of turns in this case, does it not, Mr.?
Your Honor, the Federal Liability Risk Retention Act, at sections 15 U.S.C. section 3901 to 3906, essentially at section 3902 provides that no state can pass any laws that would essentially regulate the operations of a risk retention group that's a non-domiciliary risk retention groups. And that is a core issue here. But what the appellee wants to argue is that the state cannot enact any kind of law, any law at all, that would affect the operations. And a lot of the case laws, even the most recent case of Ziegler v. the Housing Authority of Louisiana, has essentially said that those cases that the police rely on, the Wadsworth case and the Corville case, they went away from that. The First Circuit went away because those cases found, and those were the two cases that the police specifically relies on to postulate that Georgia's direct action statute regulates the operations of a risk retention group.
I think what we've got here too, look at the Second Circuit has some cases here, and then I think the 11th has some older cases that maybe kind of go the other way, it looks like to me.
Your Honor, the 11th Circuit Court of Appeals case in the Mears Transportation that we adequately addressed in our briefs in the appellate court and the lower court did address the issue of the financial responsibility. Section 3905 of the Federal Liability Risk Retention Act does provide the exception to the exemption provisions of the Federal Liability Risk Retention Act that allows the states and accepts any state laws that regards or applies and provides for the financial responsibility of the citizens of the state to be accepted from the exemptions provisions of the Federal Risk Retention Act. So our argument is that Georgia's direct action statute's not one that regulates the operations of the risk retention group. It's simply a financial responsibility law that's specifically accepted from the exemptions provisions of the Federal Liability Risk Retention Act. So what the appellee would argue would be that the Wadsworth case that we provided, if the court desires that I provide citations, I will, but they've been adequately addressed in our briefs, that the Wadsworth case and the Corville case, that those were cases involving post-judgment suits against the risk retention group. And a lot of those courts, and so many other courts in Missouri, New York, some have held that the exemptions apply, restricting the applicability of the respective states' direct action statutes to risk retention groups. But some of the states like Louisiana, in the most recent 2016 case, did in fact rule that it is not regulation that is...
Was the Louisiana case a direct action case or an arbitration case?
It is a direct action case, Your Honor. In Louisiana has a blanket provision that any injured party can sue the insurance company directly. And when you compare that to Georgia's direct action statute, Georgia's direct action statute is one that was founded based on the financial responsibility. That's where the whole thing derives from. the state's legitimate interest in protecting injured victims.
Say it was derived from the old law was you posted a bond. You had to post a bond that could be collected against. But the understanding in Wadsworth is defending against litigation, as you have to in a direct action suit, certainly involves all kinds of operations, right? You have to have counsel, you have to provide counsel, you have to evaluate claims. So how do you reconcile that? That seems more than just allowing you to collect against the bond.
Well, Your Honor, if you also look at, the Wadsworth case and the Corville cases dealt with post-judgment direct action against the risk retention groups, which are non-domiciliary risk retention groups, and those cases are essentially different from Georgia's case that was solely based on the financial responsibility. It's a financial responsibility law. I don't understand the New York statute to be not your definition of financial responsibility. It just says you have to wait till after the initial lawsuit. If anything, that's less of an intrusion on operations than having a risk retention group having to defend a lawsuit from day one. In New York, they can wait and see if you even win your first lawsuit before they have to do anything, right? Yeah, yes, Your Honor. So how is Georgia not more intrusive than New York? Well, Your Honor, I believe the court has to weigh the interest of the victims of the state of Georgia against the interests of the risk retention groups. We don't have to weigh anybody's interest. We have to read the text of the statute, not. Do we get to just make it up because who we think should win? I don't believe you have to make it up. The thing is that so many other states are at odds with how to proceed one way or the other. Even in Louisiana, the First Circuit's case and the Corville case was the Fourth Circuit went away from the holding of the Corville case, which relied extensively on the Wadsworth case, and the court said, look, we're not going to follow the First Circuit Court's holding, relying on the Corville and the Wadsworth cases that went in line with what you just asked. I'm just trying to figure out, how is it not an intrusion on regulating the operations of a risk retention group to require them to hire counsel and defend a lawsuit before you've even gotten a judgment against the insured? Well, Your Honor, the same application, the same direct action statute applies to all the insurance companies. I think some of the courts, the Missouri case, the court said, look, this is not a discriminatory law against the risk. Wadsworth says discrimination is not the test because there's actually another provision about discrimination. So the preemption clause can't be about discrimination because there's a different provision about discrimination. Yes, Your Honor. So again, how is it not an intrusion on operations? Well, Your Honor, every traditional insurance company like the Allstates and State Farms have to go through the same thing. Allowing one set of insurance companies to do something different. Right. Allowing one set, there's a federal law on one set, right? That's not applicable to Allstate and State Farm. Well, Your Honor, that's correct. There's also the specific exception to the exemptions provisions of the preemptive provisions of the Federal Liability Risk Retention Act. The one thing that is very clear is that the courts in the respective states have not adopted a very uniform posture in deciding whether or not the direct action statutes in their respective states are essentially regulation as viewed or passed into law by the Federal Liability Risk Retention Act. That's why this section 3905 of that act specifically excludes any financial responsibility laws and requires this organizations and the risk retention groups to comply with any specific provisions regarding financial laws. How do you fit this in? Yes, obviously we in Georgia do have a direct statute, but obviously suing directly is in derogation of the common law and strict construction. How does that factor into your case here? Well, Your Honor, the direct action statute, like I said, it applies across the board to all insurance companies. The law specifically provides for that. The provisions are very clear. It emanates from that need to protect the citizens of Georgia from. I get the emanate and derive thing. What it was emanating and deriving from was a bond,
right? But it's not that anymore. It's not just the financial responsibility of a bond. It may serve the same purpose, but now you've got to actually litigate your claim, right?
Well, Your Honor, it's not just bond. The statute does provide bond, a surety, or certificate of insurance. It's not just bond. The previous statute, the Title 46 of that statute did provide that, but the Section 41-112 of the Georgia Code does make this applicable to all the risk retention groups and other traditional insurance companies, like the Ziegler Court said in Louisiana, or in the Missouri Court stated in some of the other cases, that we are not passing laws to regulate the operations of the foreign non-domiciliary risk retention groups, that this is an across-the-board application to protect the interests of the citizens of Georgia, and that such direct action statutes do not regulate the operations. Even the Ziegler Court did expatiate on the word operations. I guess the key thing here is operation. How does a direct action that affords the citizens of the state of Georgia the right to sue a financially responsible person, how does that impede the operations of a risk retention group? The courts have held that that's not operation. It's not a regulation, it's not one that regulates the operations of the risk retention groups. It's an across-the-board application. Some of the courts even went further to state that if we were to have the other traditional insurers to essentially comply with this law and then accept or exempt risk retention groups, then it would be a discriminatory application. I think it's an across-the-board law that governs and applies to all insurers across the board.
Mr. Jason, what do you say to the Second Circuit authorities, I guess is what the Second Circuit's authority?
The Second Circuit, in what case, Your Honor?
Wadsworth, right?
I've got it right here. Wadsworth, I think.
The Wadsworth case,
it looks like it's kind of giving you a hard time. That one might be a little tougher.
Your Honor, the Wadsworth case, it's the New York version that permits suits against insurance companies after unsatisfied judgments. We in our responsive briefs and our briefs, we drew the distinction that law is essentially different from the Georgia's direct action statute because this is a prejudgment provision. I understand.
Explain why that is less disruptive of operations. That in New York, you can wait and see if there's even a judgment. In Georgia, from day one, you've got to be involved in a lawsuit. How is that less, whatever the disruption of operations is, how is it less disruptive to have to do it earlier in a case?
Well, Your Honor, I don't believe that the state legislature intended to. If you look at the history and the purpose of the direct action statute, it's essentially very clear. Even this court in the
I get your explanation of purpose. You said the key is operations. And you said the difference between Wadsworth is it only disrupts operations after you get a judgment against the insured. And in Georgia, you got to do the exact same things earlier. So how is that less disruptive? How do you distinguish Wadsworth on that ground other than saying the laws are different, but they're not different in a relevant way? Or is Wadsworth just wrong?
Your Honor, I believe so, and I think the Ziegler case, that was a 2016 case, it was post the Wadsworth and the Corville case. The court essentially and specifically expanded on those two cases, and they went away from it, and they found that the direct action statutes do not regulate the operations of the risk retention group. And I do believe this is a case of first impression in the state. That's why it's very important that that our Supreme Court protects the citizens of Georgia who may be hurt by these very dangerous vehicles plying the roadways.
If you are a Vermont RRG like this company, then you have to monitor the 50 states and figure out which ones have direct action lawsuits and which ones don't, so that you make sure you're not in default or you end up in bad faith litigation. So you have to monitor Georgia. Do you know how many states have direct action, how many don't? Do those ever change over time?
Well, Your Honor, the cases have not been uniformed in being, even the ones that the police rely on, the Wadsworth, Corville, the Fourth Circuit in Louisiana went away from it. And I think that is the state that I implore the court to review.
But isn't that the issue? It's preemption, so that if you're regulated, if you're a risk reduction group, you don't have to figure out exactly how everything works in 50 states. You can just get chartered in your home state and follow the federal law.
Well, Your Honor, my response to that, and I'm very short on time, would like to reserve the rest of my time, but just in parting, the appellants request the court reverse the grant of summary judgment to the appellee in the Superior Court of Newton County. Thank you. May I reserve 19 seconds?
Yes, sir, Mr. Jason. Thank you, sir. And Mr. McMickle.
Good afternoon. May it please the court. Your Honor, I think that the questions are drilling down right where the heart of the matter. The Liability Risk Retention Act of 1986, I'm sorry about that, was clearly designed to make it easier for risk retention groups to operate in an interstate or at least in a multi-state type environment. And just as Justice Namia said, it was designed...
Mr. McMickle, you may get that thing just a little closer to you. Somebody may have a little difficulty here.
Okay, sorry about that.
Thank you.
The entire design of the statute was to encourage risk retention groups to lower liability insurance premiums, to encourage the proliferation of liability insurance. And, Your Honor, you talked, Chief Justice Hines, you talked about Wadsworth, and then we've heard a lot about Ziegler. There's really sort of two lines of cases, if you will. There's, on the one hand, what I would call the strong majority position. You've got the Wadsworth case. You've got the Corville case, which is a Court of Appeals case in Louisiana. You've got the Speece case, which is a recent Supreme Court of Nebraska case. And then you've got the, I call it the Alps case, but it's the Attorney Liability Protective Services case, which is a Ninth Circuit case interpreting Alaska law. So that's the majority position on the one hand. On the other hand, you've got the Ziegler case that he mentioned, and you've got, the cases that the Ziegler case relied on, which was the King and the Sturgeon case, okay? Now, out of those collective, I think that's 7 cases, 3 dealt with direct action statutes. One was Wadsworth, the other one was Corville, and then in Louisiana you have a split of authority. You've got the Ziegler case going the other direction. So how do we reconcile these cases? If you look at Wadsworth, which I would, I think correctly so, or as Chief Justice Hines correctly noted, that case goes into great detail and talks about the fact that the Liability Risk Retention Act was not just an anti-discriminatory statute. And what it said is that, and I think it was Justice Namis that also noted this, or maybe it was you that noted this, was that 3902A4 is the anti-discriminatory provision in the Liability Risk Retention Act. There's a lot more there. In fact, 3902A1 is where the 9 exceptions to the very clear preemption of all laws imposed by states upon insurance companies comes into play. Yes, sir.
I'm sorry.
I'm sorry. Thank you. So, Your Honor, the question that was that led the Ziegler court and the King court and the Sturgeon court astray, if you will, is that, well, the conclusion, as I say, not the question, is that they concluded that it was just an anti-discriminatory statute. So I submit to you that just looking at the plain language of the statute, looking at the fact that it exempts all laws of states, the fact that it has its own anti-discriminatory provision that's buried toward the end, I would encourage you to look at 3902A2 and A3. Those statutes or those provisions of the Liability Risk Retention Act can't be reconciled with the conclusion that it's simply an anti-discriminatory statute. 3902A2 talks about states being unable or precluded from requiring the risk retention group to join the State Guarantee Association. Well, that right there tells you very clearly that risk retention groups are a different animal. The next one deals with having brokerage, state brokers sign off. So it's not necessarily substantive. I don't want to say that. but it definitely delineates between insurance companies on one hand and risk retention groups on the other. So, you know, this may be a much easier decision to the extent that decision's not easy. What I would submit to Your Honors is that when the Liability Risk Retention Act came out, the Georgia legislature recognized it in 33-40-1 and said we're basically passing this line of statutes to comply with the Risk Retention Act. And what they said in 33-43 was that with respect to risk retention groups chartered in Georgia, they're subject to all of the laws in Georgia, just like another casualty or liability insurer might be, you know, the same laws that they're subject to. But then they go in the next statute in 33-44, and they say with respect to non-chartered risk retention groups, or foreign risk retention groups is the way we refer to them in our briefs, the only laws in the state of Georgia that apply there are the ones that line up just below, or that are in that statute. And it says specifically in this code section. And what the trial judge did, correctly so, is say, look, we don't need to get into federalism issues and that sort of thing. The Georgia legislature tells us what laws apply to foreign risk retention groups in 33-44, 40-4, and this analysis is over. So I would submit to you that it's an easier place to be, but I think that at the end of the day, it seems as though Your Honors have already read the Wadsworth case and probably the Kerrville case and those sort of things. And if you compare that to really what I would say is the conclusion in the Ziegler case, because if you try to find some reasoning in the Ziegler case, you won't find it. It's a very conclusory, maybe it's results oriented, I don't know. But all I know is that there's no reasoning in that decision, certainly nothing there for this court to hang its hat on. And so when on one hand you look over here and you've got Ziegler, and on the other hand you look over here and you've got the Ninth Circuit Court of Appeals, which is not exactly a conservative jurisdiction when it comes to insurance, and then you've got the Second Circuit, of course, both in line on this exact issue. I don't know that that's a tough call either. Now, Chief Justice Hines, you mentioned the Mears case in the 11th Circuit, and I want to address that. The first thing I should say is that with regard to this argument that, or this assertion that 3905, either A or D, which is their exemption for the financial responsibility rules, that argument was not made at the trial level. So it's not in the record, so that argument has been waived. Now, if we can get to Mears from there, and you look at Mears, what Mears said was, well, what happened in Mears is that the state of Florida changed the way that you could prove financial responsibility. And essentially what they said is that we're not going to allow a filing, something like you probably heard about a Form E in Georgia. They have something similar in Florida. Well, what they said is we're not going to allow an insurance company that is not a signatory or a participant in the Florida Insurance Guarantee Association to be able to issue these Form Es or whatever their state equivalent might be, okay? So the risk retention group sued, saying that that was a discriminatory act, okay? So there was some element of discriminatory intent behind it, but it's really a simple decision when you look at Mears. What Mears says is that 3905D specifically says that states, for the purposes of either the form or the proof of financial responsibility, not more, it's a pretty narrow lane, can include or exclude risk retention groups from entities that can be behind those forms, if you will. So in other words, the exception in 3905D was spot on, and it allowed this act, specifically allowed this act. Now, so there is a lane, if you will, with regard to the form or type of insurance that can satisfy a financial responsibility regulation. In other words, a state under 3905 A and D can do that. That's not what we're talking about. What Mears, and you'll see the language in Mears, it says that the Florida statute was extremely narrow, all right? So that's consistent with the 11th Circuit saying we get that there's really pervasive or extensive preemption here, and that we're only going to authorize or accept an extremely narrow statute. And then the 11th Circuit went on to conclude that that statute specifically fits within the exact language of the exception in 3905D so that it was allowable. Completely different deal than what you've got in front of you here. If you want to start saying that, well, direct action statutes, which require lawyers to be hired, are in the case, I mean, they cost insurance companies money, they cost insureds money. It's a whole different deal if you're a trial lawyer. If you've got, well, OOIDA's insureds are, as Mr. Jason said, mostly small truckers. We like to say they're typically a guy with a truck and a dream. It's a whole different deal in a jury trial to defend a guy with a truck and a dream who doesn't have, you know, something that looks like a big insurance company sitting behind him. In other words, direct action statutes, almost every state that's looked at it in the union has said that it's very reasonable to conclude that it has an impact upon the value of a case. So I would submit to you that I think that there's no basis under the Georgia statute 33-40-4 to even go any further in this case than to say the trial judge got it right. The Georgia legislature recognized the limits on risk retention groups and specifically said that the laws that apply to risk retention groups are in that statute, and none of those laws obviously include the direct actions. That's a statute here.
Just to cut to the chase on it, then, if I can, I ask you at this time, Mr. You're just saying preemption, aren't you?
Sir, well, I'm saying there's sort of two paths to an affirmation here.
Right.
Number one is, well, you know, if I'm trying to be as intellectual as possible, the reason that the Georgia legislature passed 33-40-4 was an acknowledgement of the scope of preemption under the Risk Retention Act. Now, they didn't really say it, but we can read that into it, I think, very reasonably so. And the short answer is yes, that's exactly what I'm saying. I think the Wadsworth case went through the intent behind the statute. And I would also say, if you have any question about the intent or the purpose behind the Liability Risk Retention Act, the National Risk Retention Association filed an amicus brief in this case, and they did an excellent job of going through the history and the intent behind the Risk Retention Act. They also did an excellent job of explaining the distinctions between, on the one hand, the Wadsworth, Corville, Speece, those other cases that represent the strong majority position, and then on the other hand, showing really what is a complete lack of analysis in the only case that really stands for their position, which is the Ziegler case. So let me see if I had anything else, Your Honor. The other thing, Your Honor, that I will point out is that in this case, the direct action statute is not a gateway, if you will, to a recovery. There's no issue of coverage for this entity under our policy. We said that in our brief. So really what this case is about is whether or not I'm going to try this case with James Powell, DBA, Zion Train Express is my only client, or whether or not sitting next to him is going to be a representative of the OOIDA Risk Retention Group, represented, by another lawyer or not. We're not sure how that will work out at trial. So this is really, there's a procedural feel to it, but the impact is substantive. And I would say that when you talk about direct action statutes and whether or not that's a substantive or a procedural type issue, federal courts in Georgia allow direct action cases in front of them in diversity cases. So it's obviously been concluded to be a substantive right. And it obviously costs insurance companies money. And I think that's true. So, Your Honor, again, 3905 A and D argument was not raised at the underlying court, so I don't even know that we need to go there. But if you do look at A and D, those are very narrow exceptions, as noted by the Mears case, and those exceptions simply do not apply here. Your Honor, I hate to finish early, but I think I've said what I need to say.
We never regret that.
Thank you so much. Have a good day.
Thank you. Thank you, Mr. McMickle and Mr. Jason. You just got a short time, sir.
Your Honor, may I have the rest of Mr.
You know, that probably would be a good thing, but we better not do it this time.
Judge Nehemiah's had me on the cross-examinations as my, oh my God.
But did you raise?
Your Honor, the council's argument that we did not raise the Section 3905 argument is incorrect. We did. In the reply brief of the appellants, we did address the Section 3905 exceptions to the exemption provisions. And the Mears 11th Circuit case was one that held that the risk retention groups must comply with the state's financial responsibility laws. And that's what we are.
Did you raise the financial responsibility exception in the trial court?
Yes, Your Honor, we did. And our appellate briefs, I've got a copy of the reply brief, I'm sorry. The 3905 was raised. And so counsel's representation is incorrect. Thank you.
Thank you, Mr. Jason. And thank you, Mr. McMickle. Gentlemen, thank you. Be safe if you travel back home. Thank you.